What we're going to be doing today is going through, on my part of it, some of the new employment laws here in California that you need to be aware of, some of which may not necessarily affect your organization, and we'll talk about that, but most of them that will. And I'll explain what I mean by that when we go through some of these new laws. Luckily here in California, this year is not a terribly onerous year. In terms of new laws, there are some things that you need to be aware of, and you need to make sure that you're updating your handbooks and your other employment documents to be in compliance. But it's not, I've been doing this quite a while. I've had years where I could spend 5 hours talking about the new laws, and fortunately this year is not one of those. So I'm going to be talking about that for a few minutes, and then Carla is going to be coming up and talking about some of the things you specifically need to do from a compliance standpoint when it comes to maintaining some of the exceptions that apply to religious organizations. There's certain laws in employment that don't apply to religious organizations, specifically religious not-for-profits. And Carla's going to be talking about how do you make sure that your posters, your handbooks, other policies still give your employees the information that they need about the laws that we do follow, but also doesn't waive our rights to assert the exceptions that apply to religious organizations. And at the end, as Travis said, we will have time for a few questions to review to you. So let me get started. First of all, yes, I'm a lawyer. This is what we do. We give disclaimers, right? You know, you hear them all the time on those radio ads with a disclaimer, but it's really, really fast. All right, I'm not going to do that. But the basic thing I want to share is that every situation that comes up in employment especially is always unique. And so although we're going to be talking about some general principles here today with respect to these new laws and to policies, when it comes to the specifics at your organization, it's always important that you reach out and you get legal counsel that can take into account the specifics of your situation. Now, the good news is, through Church and Casualty, you can reach out to Ask Legal or Ask HR, and we'll respond and give you a little bit of direct guidance if it comes to that, or you may have your own counsel. But it's important to keep that in mind as we're going through today's slides. We're talking more generally, and every employee situation is always different. Okay, so one of the things that the legislature decided to change this year is the rules regarding paid family leave. So paid family leave is this program here in California that is run through the EDD, the Employment Development Department, and for employees who the employer and the employee pay taxes on SDI, they are eligible for paid family leave benefits. So if they have to take time off from work to care for a family member that is seriously ill, or to care for a newborn baby, which is most of the most common reason why people take PFL, they can apply to the state and they can ask for wage replacement. And the state will pay them up to 80%, yeah, 70 to 90, yeah. It can be almost their entire wage that gets reimbursed. So, how does this apply to religious employers? Well, religious employers do have the ability to choose whether or not they are going to pay into unemployment and SDI, right? So if your organization has made that choice and does not pay in, then you don't need to worry about this. But if your organization does pay in, and people who work for your organization are eligible for paid family leave benefits, here's the change that you need to be aware of and you need to change in your policies. Under prior law, if the employee came in and said, hey, I want to take baby bonding leave, I'm a new dad, I'm going to take up to 12 weeks. The employer would have the ability to say, before you go to the state and get PFL benefits, you have to use your accrued vacation, or PTO, up to 2 weeks. The legislature changed that, so effective January 1st, employers can no longer require employees to use that 2 weeks of vacation before they go and apply for PFL benefits. In other words, the employee can say, I'm going to save my vacation because I want to go to Mexico, right? And I am just going to apply immediately for PFL benefits and just get paid by the state. So if you do have PFL benefits available to your employees, make sure that you're changing your policies and your payroll practices to reflect that change. So pretty simple, straightforward, right? Okay. Here's the next one. And this may or may not apply at your particular organization, but one of the things that employers sometimes do is say in their job postings that a driver's license is required in order to be employed in that job because the job involves driving. This new law, SB 1100, says you cannot make having a driver's license a job requirement unless it is what we call a BFOQ, a bona fide occupational qualification. So, if I make a posting for truck driver, probably a bona fide occupational qualification that I have an actual license and probably a commercial license, right? Okay? But a lot of times we have jobs where people may be required to drive on occasion, and in those circumstances, if you can show that it's reasonably expected that that person is going to have to drive, not commute, this is where a lot of employers get hung up because they think, well, they got to be able to drive to work. If they don't have a driver's license and they can't drive to work, they're not going to show up on time or they're not going to show up at all, so I'm not going to hire them. So I'm going to require a driver's license in order for them to apply for this job. Can't do that anymore, okay? Only if it's reasonably expected that they will drive as part of their job duties and that there's no alternative means of transportation that isn't significantly more costly or interferes with the job. So in other words, if someone says, well, hey, if I have to go out to the church annex that's across town occasionally to pick something up, I can take Uber. Okay, well, Uber would be roughly about the same as what I'd have to reimburse you for your mileage, so that's not a problem. In that circumstance, you can't require the the driver's license as part of the job posting, okay? Now, here's where it gets a little bit tricky. So, if your organization is a non-for-profit religious corporation, okay, not just generally a religious entity, but actually a non-for-profit religious corporation with the state of California, okay? The Fair Employment and Housing Act, FEHA, which is the general law in California that governs discrimination, does not apply to you. You are not, for most purposes, okay? You are not an employer subject to FEHA. And this particular new law is in the part of the FEHA that does not apply to non-for-profit religious corporations. However, it does apply for non-for-profit public benefit corporations, which some religious organizations are. For whatever reason, they selected that corporate structure. So in terms of whether or not this applies to you, And this comes up often with schools, right? They may be affiliated with a religious organization, but the school itself is not a religious corporation under the California rules. Those circumstances, this new law is going to apply to you. Now, I know that creates a lot of questions usually, and we will deal with some questions, and Carla's going to be talking in more detail about this at the end. But I just wanted to point that out. This doesn't apply across the board to all religious organizations. Okay. This is the one that's more complicated in terms of our new laws. And some of this is already part of the law, but some of this is new, and I think it's important to understand what these leave rights are, because these leave rights generally are going to apply across the board to various entities, okay? So this has to do with domestic violence, sexual assault, stalking, and violent crime. And all of those things previously, if people were victims of those types of acts, were protected under the Labor Code. And this year, the legislature decided we are going to take all of these protections and put them into the FEHA. But they put them into the part of FEHA that does apply to religious employers. So this is across the board for both non-for-profit religious corporations and any other type of religious employer. Okay? So, what are these protections that are now part of the FEHA? And why is that important that it's been switched over to the FEHA? Okay? So, when it was in the Labor Code, if you felt like you had your rights under these laws violated, you could go to the labor commissioner, the state labor commissioner. And the state labor commissioner's office is so backed up that it would take years before your case would be heard. So the legislature said, no, we're going to put this in the FEHA because now it creates a private right of action for people to sue their employer under FEHA. So the whole intent of this is to keep people like me more busy than I already am. Because now you're going to have plaintiffs' lawyers, employee side lawyers, who are going to be more attracted to suing under this particular law. Why are they more attracted to suing under this particular law? Because if they win anything, they get their attorney's fees paid automatically. So that is why the legislature decided to move it from the Labor Code over to FEHA. So I'm going to talk a little bit more detail about this, but some of the protections for people who are victims apply to all employers, and some apply only to employers that have 25 or more employees. So I'm guessing a lot of you probably are in your organization have less than 25 employees, W-2 employees, and some of these aren't going to apply to you. But if you do have more than 25, then there's additional requirements that you have to follow. Okay, so one of the things that it's important to be aware of, and is an important new requirement, is you have to give notice of these rights to all employees upon hire, and of course you have to include them in your job postings. So the best way to do that is to include it in your employee handbook and to make sure that all new hires get your employee handbook that contains all of these rights when it comes to victims of these types of crimes. But you also have to make sure it's posted. So keep that in mind as well. Okay, so all employers, no matter the size, are required to refrain from retaliating or discriminating against employees who go on, and this is the biggest change in this law, by the way, jury duty. There was no protection in California prior to this for people who were called on jury duty. But now, as part of the FEHA, if someone gets called on jury duty and they're seated on the jury, their job is protected. You have to reinstate them. Doesn't mean you have to pay them, but you have to reinstate them. Secondly, if someone requests time off to comply with a subpoena to testify, or they're requested to testify as a witness with respect to a case of domestic violence or stalking or serious violent crime, any qualifying act of violence, and I'll give you that definition in a second, then their job is protected. You cannot discriminate or retaliate against them. And finally, if they need time off to seek a restraining order or injunctive relief to protect themselves or their child, their job is protected. So, what is a qualifying act of violence? This is someone who is subjected to domestic violence, sexual assault, stalking, or a violent act. A violent act is an act causing bodily injury or death, or an act involving the brandishing of a firearm or a deadly weapon, or where someone has threatened to use force that would cause physical injury or death. These are all qualifying acts of violence that give employees the ability to take time off for those purposes of getting an injunction or testifying or seeking, being called to testify pursuant to a subpoena. Now, there's no requirement under this law that the perpetrator be arrested or convicted. So the employee doesn't have to come in and say, hey, for instance, my spouse got arrested for domestic violence. Here's the arrest report. All they have to do is have something, maybe a medical report, that indicates they were a victim of domestic violence. And the protections here would be triggered. And again, this applies to all employers, no matter the size. Okay, now it gets a little more complicated. What if you have more than 25 employees? If you're a larger employer. Now, you can take time off if either yourself or a family member is the victim of one of these listed violent acts. So, any of the qualifying violent acts that we talked about previously, domestic violence, stalking, sexual assault, or some sort of violent act involving brandishing a gun or bodily injury or death, that type of thing. So, and the types of reasons you can take time off are broader. So you'll see this is a whole list. You can take time off for a restraining order or injunction, to seek medical attention due to your injuries, to obtain services from a shelter, to obtain mental health services, to engage in safety planning, to provide care for the injured family member, to obtain legal services, to attend civil or criminal proceedings, or to seek child care necessitated by the act. So it is a much broader list of things that people can take time off for. Now, they have to still establish that there's some reason that they need to take time off related to the qualifying act of violence. I got a call yesterday from a client, and they said, hey, we have this employee. They were on FMLA for their 12 weeks, right? And then they said they were subjected to domestic violence, and so they're talking about being out for an entire year. And I was like, well, number one, which we'll talk about in a second, they may not have the right to be out for an entire year. But number two, it's not just a blanket, you get to take as much time off as you want because you were a victim of domestic violence. It has to be for one of these qualifying reasons. Now, if someone comes in and says, I'm suffering from trauma, and here's my doctor's note that I'm under medical care for my mental health problems, and I'm going to need some time off, that would qualify. But it's not just, I was a domestic violence victim, and therefore I want to take as much time off as I want, and you still have to protect my job. So what are the limits to this time off? Okay. Number one, you've got to give some sort of advance notice unless there's an unscheduled event. And then you've got to give as much notice as possible, plus provide some sort of certification of the reason why you need time off. And the total time off is 12 weeks. So the statute says that, equivalent to FMLA, CFRA, you get a total of 12 weeks of time off for one of these purposes. So that if you're taking time off for a family member, however, who is not deceased, your total is 10 days. So if you say, hey, my grandmother was a victim of a robbery and she was knocked down and she got hurt and I need some time off to care for her, then your total is going to be 10 days. But if it's for your own issues relating to violent crime or stalking or domestic violence that was directed at you, then the total is 12 weeks. Okay? Bless you. And employees can choose to use vacation or time off or paid sick days while they're taking this leave. That's up to the employee, though. You cannot require the employee to take their paid time off if they're going to take one of these leaves. So that's probably the biggest change. Some of these things were already in place in the labor code, but they've been made more explicit, and the legislature has expanded the reasons why you can take time off in these circumstances. So what do you have to do? You have to make sure that your handbook is updated and that you're giving the proper notice to new employees and your current employees on what protections and leave time is available to them under these laws. Okay, one other thing that you may have heard about, it's kind of interesting issue, is SB 399. So SB 399 says that employers cannot hold mandatory meetings with employees to talk about political or religious topics. So this whole law is an attempt to prevent employers from talking to their employees about labor unions. That is what it's about, okay? But they put this broad category of political and religious topics because they wanted to hide the reason why they're doing it. And well, no, this isn't about labor unions. This is about all political and religious topics, okay? So that's why it is as broad as it is. Now, you probably are saying, wait a minute. You're saying that we at our church can't sit down with our employees and talk about religious topics? That's crazy. Well, this does not apply to religious corporations or entities that are generally exempt from the federal and state laws regarding discrimination, which would be most all of the entities in this room. So you don't have to worry about it. But you may have heard about it, and so I want to make sure I mentioned it. The other thing I will say about this, it's going to be ruled unconstitutional. There's no way. This is a Newsom special. But I have had some questions about it, so I did want to mention it. It should not prohibit you from having religious or political discussions with employees at your particular organization. Okay, last one, because this one comes up a lot. And this has to do with the whole interplay of AB 5 and independent contractors. And I get a lot of questions from churches and schools about how do we deal with these issues. So they passed this law, SB 988, because there was a law that was passed about 2 years ago that exempted a number of freelance positions from the coverage of AB 5. And to refresh everybody's recollection, AB 5 was the law that basically said you can't have independent contractors in California anymore. I'm simplifying it, but that's essentially what AB 5 said. And then the legislature went back and said, oh, well, we didn't mean these people. They can still be independent contractors, these freelancers, right? So freelancers are people who earn more than $250 for providing professional services for things like marketing, HR, graphic design, grant writing, journalists, etc. It does not, however, include musicians and audiovisual people. And that's where I usually get the most questions. What about the people we bring in for worship and we're paying them per performance and they're independent contractors? Does that run afoul of AB 5? Is there an issue? And so there is an exception under AB 5 for single performance musical acts or musicians. Where it gets a little tricky is when you're paying somebody every Sunday to come in. Here's your $100, here's your $100, here's your $100. It starts to look more like employment, okay? But this new freelance requirement doesn't apply to musicians and audiovisual folks or guest speakers that you might bring into your church. But if you do have people who are doing things like marketing or graphic design, this new law says you have to have a contract that has certain terms in it, like you've got to have a pay-by date in the contract that is no less than 30 days after completing the services. You can't force the freelancer to take less than what's specified in the contract. In other words, you can't go to them and say, hey, I really didn't like what you did, so I know I told you we were going to pay you $500, but now we're only going to pay you $300. If you don't accept it, I'm not going to pay you at all. You can't do that. And your contract's got to have the name and address. It's got to have services and rates, the date freelancers have to submit invoices, etc. So again, I wanted to mention it because sometimes organizations do reach out to these freelance folks for work. And if you do and you're paying them more than $250, you have to make sure that you've got that written contract with those terms in it after January 1st. Okay, so I think we are at the point where I am going to turn it over to Carla.
Thank you. All right, well, there you go. There's a lot of work now to do to get all that in your handbooks. So what we have to talk about now is not new. It's the lingering problems that we have every year. And I think the ones that everyone, at the first of the year we tend to think about are labor law posters and are our handbooks up to date. And so sometimes it gets way far into the year before we might actually get those tasks taken care of. But we wanted to go ahead and talk about those again because those are two tricky subjects when it comes to applying everything that we learn in these kinds of seminars about religious exemptions and how they apply to us. So the first thing is labor law posters. And I know y'all have, I think we've talked about this in every seminar that we've done. And I know everyone would love to have a composite poster that they could order and you could put it up. And it does not exist. So it's not going to exist from us. We recommend, and we have put together a list of all the posters with the link that will take you right to that poster and you can download it. And if it needs to be modified for a religious organization, it will have the exact modification on that poster. It's already there for you, so you just got to print it. But it's not going to be a nice laminated composite poster. It's going to be a series of posters that come out there, right, and they come all different sizes, and they have different size requirements, and I know it's different and messy, but that's what we really think is the best thing to do. Even a religious employer is going to have different things that they're going to want to put on that they're going to want to display on their postings. Some religious employers participate in unemployment and some don't. Some religious employers are fine with some of the restrictions that they don't really have to be under FEHA, and they don't mind putting those up. So we really want to be careful. Every religion is not the same. There's many different religions. So we've come up with this idea and this plan. We did this in 2024. It seemed to work well. All of the guidance is not out yet for 2025, so we have not been able to bring that to speed because these laws just got passed. So once that's all out and published, we're actually ahead of time. We will update that list, and we will send it out to you, and then you choose what applies to you, run those posters. If you don't want to run them by each government entity, Labor Law Center or something like that will sell you a packet of them, and I think it was $35. So if you wanted that, you could do that. At least they would all look alike if you want to do that. But that's the deal on posters. So it's not composite, but you can be sure then that you are not inadvertently waiving one of your religious exemptions with your, by putting up a poster that all of a sudden you said all applicable laws. And oh dear, what did you just do? Okay? So that's that. Handbooks, if only it was that easy. So handbooks, I feel like once you do a handbook, you're immediately behind on updating your handbook. It is a constant issue. And, your handbook, if you've got a handbook and it was redone in 2024, you're still going to have to update it now. And if you're anything like me, you've got a bunch of handbooks that you wish they were updated in 2024. It's more like 2020, 2022. So we really need to go through and take every one of these new law seminars and update your handbook with any of these new laws. So really make sure that you've captured there. That would be the first step I would do. Handbook builders are a good start. So I wouldn't shy away from using a handbook builder. So the Chamber of Commerce has a good handbook builder. Mineral has one. It's a little bit more expensive. But there are some good handbook builders, and those are not bad to start with. Oh, sorry. Oh, great, thanks. I would, but be really careful. That's only to give you a start, because there's going to be stuff in there that would, if you just publish that, is going to do that very same thing. It's going to waive some of your religious exemptions. And the three places that I found most where you can run into trouble is your equal opportunity employer policy, your sexual harassment prevention policy, and anything to do with maternity. Click. Oh, she wants to go back. Okay, I'm sure they'll send these slides out too. They usually do. Okay, so on your EEO and sexual harassment prevention statements, keep in mind that religious employers are allowed under Title VII of the Civil Rights Act to give employment preference to members of your own religion. You are entitled to make employment decisions based on religious criteria. So that means how you promote, how you hire, anything like that. You are still subject to discrimination based on other characteristics that are federal. So that means things like race, color, sex, and national origin. That's mainly the things. So because if you are a religious not-for-profit organization, you're not subject to all the things in FEHA, but you are subject to these things in Title VII. Okay? So keep that in mind. And then the next thing is you are not subject to the FEHA stuff. So you can craft your EEO statement, leave those, make sure to keep those things in mind. And the Title VII stuff is only if you have 15 or more employees. So that's what we want to keep in mind on that. Okay, that was the easy one. And both of those, the sexual harassment and the EEO, those are the same things to keep in mind. And the sexual harassment is just because it talks a lot about discrimination in that policy. Don't y'all get mixed up on maternity in California. It's just crazy. What has happened in California is that because pregnancy disability leave is under FEHA, so religious employers are not subject to pregnancy disability leave. We are subject to California Family Rights Act, so CFRA. But because not the pregnancy disability leave, it's kind of left us without a protected leave for women who are pregnant because they don't have PDL. So I don't think anyone intended that, but it does leave a little bit of a hole there. So your organization needs to craft a policy that speaks to that. And so I put a little chart here of things that, and then all of this goes by the size of employer you are. So if you don't have, if you're under 5 to 15, all of this. So these are the things we want to keep in mind when you're crafting your policy. Now, we have crafted templates for you guys for all 3 of these issues. So the maternity policies that you'll get, there's one for each group of size of employer. Now, you can change it up however you want, but keep in mind what you're subject to. And I have put in there a kind of middle of the road, we're not subject to PDL, but, we will consider, on a case-by-case basis, a leave will be considered, or whatever it might be. If you have 50 employees, you're now subject to FMLA. So, and that does have pregnancy disability leave in it. And keep in mind that if you have an employee that takes pregnancy disability leave through FMLA, once they're done with that, then the bonding time starts. So it's not concurrent. It stacks up. But we have all of that written for you, and then you can take the templates and modify it for your church the way you want, or your religious organization the way you want. Just keeping those things in mind, I wanted to give you all the information and then a template to go by. So I think with those 3 templates, you can get a really good start on being able to take whatever builder you used, or if you have a handbook, just check these policies. I get the most question about those 3. If you have another one that is just stumping you, you can use the Ask HR, and we can take a look at it. And they're editable, so you can just do whatever you want. I think that's all I have. I did want to mention. I did want to mention, and we didn't put it in because I forgot actually. It's not a brand new law, but in July 1st of 2024. We're required to have workplace violence policies in place, prevention in place, not the policy to have it. So people forget the prevention. Just to make sure you all know that, and Church and Casualty has great templates and everything on their website, but just make sure you've gone through that process, done that, and have that. That is administered by Cal OSHA, and how that happens is if they come in to audit you, they will, if you don't have it, they will usually give you some time to remedy. If you've not been in trouble with them before, they'll usually let you remedy. But if you've been in trouble with them before, it's up to whoever the inspector is. You could get in real trouble. You don't want to get in trouble with them because once you're on their radar, it's like you never go off. So it's good to have it just in place. Okay?
2 things that I wanted to mention, just following up. Go back. Go back. Okay. Why it's so important that religious organizations are exempted from FEHA, okay? Because FEHA is a much broader anti-discrimination law than Title VII. So, for instance, under FEHA, gender identity and gender expression are protected characteristics. And if you don't, as Carla said, if you're not careful in how you craft your policies, you can waive your exclusion from FEHA. And the other reason it's so important is nobody sues under Title VII. They all sue under FEHA. So, for instance, I had a case earlier this year for an organization, a church, where their maintenance person sued for disability discrimination. And one of the arguments that we were able to raise was that this is not a properly brought FEHA case because they are a non-for-profit religious organization and therefore they are exempt from FEHA. So that's why that's really important to keep in mind when you're crafting your policies. The second thing I wanted to mention is you'll see that the column there, PDA. So that refers to pregnancy disability accommodation, which is different from pregnancy disability leave. Under California's pregnancy disability leave law, employees are entitled to up to 17 and a half weeks to take time off and are protected when they return from their disability leave. Pregnancy disability accommodation is what is required under the PWFA, which is a federal law that was passed last year, 2023. And that only applies to employers with 15 or more employees, which is why you see that on the chart. But if you're a PWFA employer, you don't have that mandated leave time, but you have to provide accommodations to pregnant employees the same as you would accommodations to other employees that have disabilities. And that does apply to religious employers. So I wanted to make sure that you're aware of that, okay? So you don't want to put a hard and fast pregnancy disability leave policy in your handbook that copies the California statute because now you bought it, right? And now you've waived your right to raise a legal argument if somebody claims, hey, I was discriminated against because they didn't bring me back in the same position when I came back from leave. But you do have an obligation to engage in a process to determine if you can accommodate that person's request for leave.